What's up, family? And welcome to another episode of Success in Business, the podcast that educates, equips, and empowers the small minority women business owner. Just hit us on Instagram at Success in Business, Facebook at True Success in Business. Hit up our website at www.successinbusiness.org. And for questions or to give podcast suggestions, email us at info@successinbusiness.org. Like, subscribe, and share with your friends and family. I'm your host, attorney Goodwille Pierre, and the title of today's episode is Fighting Back, Protecting the DBE Program and Economic Justice. This is under the bigger topic, advocacy in action, and we're going to bring you different things that come up. I had to switch it up, family. I have right here, hot from the FAA, November 20th, a memo that talks about another attack on affirmative action. And so I just got tired of this. I have this audience, and I just want to just educate and equip and hopefully empower you on this onslaught of attack of our affirmative action programs in order to level the playing field. I just don't know what to tell you, but we're going to break this down. This is going to be broken down. Initially, I was going to come to you today, family, and talk to you about the new rules that came out in May with the Disadvantaged Business Program, which is a program that's facilitated by the United States Department of Transportation. But when this lawsuit or this opinion from the Southern District of Kentucky came out that I'm going to talk about, I had to just change direction, kind of sort of pivot, because I wanted to kind of really educate and equip you guys. So this episode, we're going to talk about specifically this case, and I'm going to point out what we can do. And then I'm going to come and talk to you about in the next episode, I'm going to talk to you about the origins of the DBE program. I think that's really important because a lot of us who are DBE certified, it's a means to an end, and none of us bother to read the history or read the statute 49 CFR Part 26. We don't even know what CFR means. So I'm going to break down the origins of the disadvantaged business enterprise in a way that's not too nerdy, hopefully. That's not too law schoolish and everything. And then finally, we're going to talk about the new DBE rules. And so that's going to be something that you're going to get piecewise because it just be too much to just try to do in 15 to 20 minutes. So let's talk about this attack, this most recent attack. Now, mind you, this recent attack, like I said, was from Kentucky, and it was a judgment or order. It's called a temporary restraining order that was handed down by the Southern District of Kentucky. This is what it does, okay? We had these two contractors, okay? Well, first of all, it's very important to know that this lawsuit was brought on by this organization called Wisconsin Institute for Law and Liberty. They call themselves WILL, the Wisconsin Institute for Law and Liberty, WILL. Now, here's what I'm going to try to hit you on, family. This is like the organization who brought down that other affirmative action case that really just kind of turned everything on its head. The organization Students for Fair Admission. So this is going to come back later in today's episode, but they have organizations full with people whose sole mission is to just tear apart all aspects of affirmative action. Anything that helps to benefit people of color in contracting and education based upon the historic evidence of discrimination, they're trying to rip it up and tear it up. And it's going to be much easier, I'll tell you, with this new administration. And that's going to be another episode. But let's just focus on the DBE program because a lot of my family members, guys, you guys are dependent on this for economic equity because in the past, you haven't been able to get contracts. So let's talk about it. So you know who the organizations exist for their sole purpose. And they file these lawsuits because they claim that their members have an issue. Now, we're going to really discuss that for all you members of the Black Chambers of Commerce and all these trade associations like AMAC and NAMAC. I'm going to hit that. It's going to make a lot of people upset, which is going to be the point of this particular episode. That's why I had to hit this first. So let's get back to the lawsuit. These two kind, I'm going to read it because I want to make sure I get it right. Mid-American Milling Company, they call MABCO, and I'm going to read it, Bradshaw Trucking. They sued the United States Department of Transportation. Now, here's where I'm going to slow down and break this down to you because you need to understand it. And this was hinted in a decision of the Students for Fair Admission. In the Disadvantaged Business Enterprise Program, there are two rebuttable presumptions. There's the social disadvantage presumption and the economic disadvantage presumption. You're going to get on that definition later on in a later episode. If you are Black, Hispanic, even women, white women, you are presumed socially disadvantaged, but it's a rebuttable presumption. That means that anyone could come up and rebut. They have a right to rebut the fact that you are socially disadvantaged just because you are African American, or just because you are a Hispanic American, or just because you are Asian American. That's very important. What these two contractors did, and mind you, this is the same as a scheme, so it's not like they decided to just do this. They were recruited, just like back in the day when we wanted to have these programs instituted, when we would be discriminated against and told to get back on a bus in the 60s, mind you. This wasn't that long time ago. That hadn't been 100 years. We had people who were good test case models to bring things to court. Now they're doing the same thing to us. So this Will organization, Wisconsin Institute of Fair, whatever their name, got these two contractors. And what the argument is that, hey, judge, we have a problem because the rebuttable presumption at this day and time in 2024 that African Americans are socially disadvantaged compared to all the white folks is discrimination against us good white folks. In fact, it's discrimination against everyone. And you need to stop it. Now, check this out. Here's what they're saying. And this is why I'm gonna tell you, I don't know how to be upset. You know, when you get people to kind of do things, and some of the stuff is right, some of the stuff is messed up. That's why this is so clever. This is what they're saying. They put in their arguments already to argue for this type of restraining. Basically, it's a thing that want to just shut it down, but it's restraining order on contracting and what the goes on. I need to clarify that. But let me just get down, because it's very important, family, that you understand this and that someone breaks this down to you, and why it's so important for us to really start really receiving this and find out what we can do. And I'm going to go these different ways in this particular episode. This is what they're saying, okay? They're saying that, hey, we're trying to do some contracting, but you have these goals, and that the people who are certified disadvantaged business enterprise, they're not socially disadvantaged. They're not. You can have a person who may have went to Harvard, for example, and is a lawyer. They're saying how that Black person is socially disadvantaged. Or you might have a person that doesn't live in a neighborhood where, in their eyes, real social disadvantage, but because they live in another neighborhood, they're not socially disadvantaged. The fact that you are African American does not give you an automatic ticket to be called socially disadvantaged. Okay, that's what they're saying. Now, what they're also saying is, hey, they anticipate the Department of Transportation, and they were the defendants, are going to come back and say, hey, discrimination still exists. Hey, it's still not working. Hey, there's still more things to do. So their argument is saying it's failing. Their argument is that, hey, you guys are trying to use this program that is not working. So not only is the program, which has only been existent for a second, is not working, but you're discriminating against us trying to make something that's faulty work. That's what the argument is. Now, I broke it down in Goodwille Pierre language, but that's what they're saying. They're saying that the program is busted, disgusted, and needs to go away because what you're trying to do all these years is not working. And they're getting into the crux of the matter by saying that, hey, it's not narrowly tailored. Now I'm jumping. I'm about to mess you guys up, so I don't want to get nerdy. The lawyers know what I'm talking about. But anything that's racially motivated from a civil rights perspective has to pass certain level of tests. They call it scrutiny. And the highest level of scrutiny, they only deal with Black folks, is strict scrutiny. Women, LGBTQ, anyone else, medium or low scrutiny. So when it deals with people of color, in particular black folks, because if you look like me, you can't pass in any other racial category. Strict scrutiny. That means it has to be narrowly tailored. The program has to be narrowly tailored to meet a compelling state interest. Now, I'm not about to talk about civil rights law or 14th, Fifth Amendment. Let's just say that it's being attacked. So what the judge did, okay, while we're working it out, oh, by the way, in order to get a temporary injunction, several things has to happen. Three things in particular. One, the judges in this case have to believe that you have proven your burden by showing them that you have a reasonable likelihood to succeed at trial. So in other words, the first thing they said was, hey, if we took this all the way to trial, you're most likely going to win. They already made that determination. Then they've said, hey, it's going to cost you irreparable harm if this was going to happen, meaning that you're going to suffer damages that you can't can't return from. Then the final thing is, and it kind of differs in different courts, but in this court, it's not going to do the DBE certified people any harm by doing this temporary restraining order. And that's what the temporary restraining order says. Family, I was blown away. And I'm going to tell you why I'm not so much blown away by the order. I'm blown away by other things that has occurred that we have not done as a people benefiting from the DBE program. When I'm getting to that in my closing. So this is what they said, okay? And let me read these companies again. I'm reading now. Mid-American Milling Company and Bradshaw Trucking Company, all right? This is what the judge says. Give me all the states that you currently are doing business. Then give me all the states that you plan to do business in. And what we're going to decide to do is all those states that have a goal on federally funded project, a DBE goal, recipients or sponsors, recipients are the people who receive the grant funding. Sponsors are the people who give them. You got to bring those goals to 0%. You have to bring those goals to 0%. That's what the judge says. And you do that while we're working out your real argument. Mind you, the lawsuit is saying that the United States Disadvantaged or Department of Transportation Disadvantaged Business Enterprise program is unconstitutional because it discriminates, because it uses race-based programming in the form of a rebuttable presumption that being black is automatically social disadvantage. But it's rebuttable, so anyone can rebut it. They're saying you discrimination. But so while we're working on that, as the judge says, we're going to just stop all goal-oriented projects. So I got here, right here from the FAA, some guidance. About 25 states on how they should change. Now, a lot of stuff has been happening since 2023 concerning these lawsuits, okay? But I'm telling you, it really began some time ago in the Ninth Circuit decision. And I'll get that for you somewhere. I can't remember, but the Ninth or the 12th Circuit. So in California, let's put it that way, in California. So all you lawyers, please forgive me by messing up on the circuits, but the California area where they ruled that it was unconstitutional, the implementation of the Department of Transportation DBE program. So the United States DOT, they still were safe, and only individuals in that area, that circuit, had to change how they will do something until they get a disparity study, okay? Which a disparity study is a study that shows disparity in contracting. So let me pause right there. Even when you do what the cases in Adirondack, all the other cases have said, and also recently in the 12th Circuit case, where you do a disparity study to show that there's still existing discrimination. And what it means is that in all your contracts over the past 5 to 7 years, you have all these contracts, all these millions of dollars, and it's going to white folks, but very, very little, small percentage going to black folks. Until you show that fact, you can't have a program. Well, that case was the local implementations of the program. It didn't affect the actual DOT program. Now we have a case that affects the DBE program. And what it is it also last year or early this year, they did the same thing for the 8A program for the Small Business Administration. And what they're doing, and it's a controlled program effort by all these organizations, they are attacking the core track or the core purpose of how and what defines a person as being eligible to be certified as a DBE, disadvantaged business enterprise. And that is social and economic disadvantage. And so the rebuttable presumption is how they're attacking it, just like in the Students for Fair Housing. And I predicted this would happen. And look, it happened quicker than I thought, actually. I predicted it. People smarter than me predicted it. And we sat around and let it happen instead of going on offense. And this is what disturbs me. We knew what's happened from the 12th Circuit case, okay? We knew that this was their plan. They knew his plan. They started with voting and redistricting. They started with all these other things. Then it always starts in education. So back in the day, before Adirondack and Carson, it was Bakke. Okay, University of California versus Bakke. I know I'm throwing out case law to you. And then we came up with different ways to abide by the court's decision and the strict scrutiny. Now, they're coming back using the same arguments that we have used to say that we're discriminating against them and everyone else. So there's a lot of things that can be said. But let me tell you what this means again. And then I'm going to go and talk to you about 7 different steps that I believe that we need to do now. And then we're going to save the next episode to talk about the origins of the Disadvantaged Business Program. But I think you have to, if you don't know where you come from, it's hard to write a path to know where you're going. So let me make sure I get this right. 0 DBE goals on some contracts. Any federally funded contracts, these companies bid or will not require DBE participation. And then a broader impact is the ruling currently affects contracts in 25 states, including Louisiana, Texas, Georgia, Florida, but it could expand further. It's ridiculous. Now, if these 2 companies can do that, imagine what can happen with many companies, coordinating to do the same thing. It's coordinated, it's planned. So everyone who's a member of these contracting associations, because they allowed you to get in, and I'm not, you're a business person. We got to be part of the equation. You got to be at the table, or else we're going to be the meal. I get it. Yes, I subscribe to that philosophy as well. But then when the meeting is over, then they get another meeting in which that same person who looks like me appointed to all these high positions, they're planning to do away with the very thing that got you to that table. Because they don't want anyone else to have opportunities. Anything that creates equity appears to be unfair to people who are privileged. And that's the problem I have. So let me throw down these 7 steps, because I can talk forever, okay? Step 1, educate and mobilize the DBE community. So this is what's happening. Everyone is a member of these chambers. It could be the Hispanic chamber, it could be a Black chamber. A lot of times, also National Minority Supply Development Council. Look, we have to switch up. We have to change our mindset. We're raising monies. We're doing golf tournaments. We're sitting and having conversations with private entities and public entities. But there's no concerted effort to really have the conversation and file the lawsuits. We're always responding to lawsuits. We have to file what's called amicus briefs, okay? Friends of the courts. We have to file it. We have to pool our money together and hire attorneys. Don't go to people like me and try to get it done for free. You got to hire some attorneys to really be responsible. Airport Minority Advisory Council, National Association of Minority Contractors, we have to get on the offense right now. We are actually behind the ball, and we have to actually start leading, thinking, and planning strategically like a chess game. So the education website, webinars, workshops provide resources for DBEs on how to advocate for their rights. Yeah, we've been doing that, Congressional Black Caucus and everything like that, but it has to be more coordinated. It has to be serious, okay? I mentioned number 2, advocate for amicus briefs. Those are friends of the courts. Those are friendly courts. In other words, coming together as organizations to file your own briefs to provide different insights to the court. Whether it works or not, we have a framework. We have a pattern of things, and they know we're not going to just lay down. Now, other people have done this, but very rarely it's the ones that matter, okay? Now, pressure state and local governments, okay? This is the deal. We cannot hold up on the pressuring, meaning that everything from showing up at the state conference to doing what a lot of other organizations do and just stop buying stuff, stop traveling, stop going places that do not want you to have a fair, equal opportunity to compete for a project. Stop, just stop. And everyone who supports people, I'm going to wait and get advice before I start naming names of folks in online marketplaces. But we have to do that. We have to do that. Now, I know it's going to be hard because as Black people, the only identification we have is when something goes wrong, when someone gets beat by the cops, or when something goes wrong. It's not a shared interest sometimes of collectivity because they always find one person to benefit, and then the other folks who are against it say we've done enough. Okay? It's really bad. Engage in congressional advocacy. I mentioned that. Monitor and address shortfalls. Now, here's something that's really, really, really sensitive subject to everyone. I'm in Houston, Texas right now. There was a disparity studies done by Metro, by other organizations, and they have not even released it. Political issue. They have not released it. And what's happening is the organizations who are charged, who people pay dues to advocate on their behalf, don't want to do anything because their friends, people that look like them, are in those positions. Well, it's amazing how other folks, majority folks, can just come up and not care about how the organization being blackballed by that particular state entity or that city government. They're not afraid of being blackballed, but we are afraid of being blackballed. Isn't that ironic? Blackballed Black people. We don't want to be blackballed by our own folks. We don't want to make them mad. There's some good government jobs. Why are you messing around with me? I hear this. Or better yet, I don't got time. I'm trying to make money. Or I don't want to mess them up because they know who I am. But the other folks, I don't care. Here's another thing. A lot of these organizations are not following the rules anyway. That's why I can't really be mad sometimes at the individuals who filed this lawsuit because they're not following. So no, for example, there are agencies right here in Texas that we know that organizations use DBEs to get the contract, but then when they get the contract, they don't ever call them, they don't use them. Then it creates some crazy excuse why not to use them. And when you complain to the local recipient, they don't do anything, or they give excuses, or they make it so difficult for you to just get justice. Excuse. And it's intolerable. We got to hold them accountable. Finally, raise public awareness and strengthen legal defense. I'm doing my part, but I'm just a small person trying to get more followers. We have to make people be aware. We have to have this conversation. And legal defense, we have to put money in the program. Collaborate with legal experts, colleges, universities, provide resources to the Department of Justice, FAA. This is serious, guys. And it's not going to change. It's just going to get worse. So that's it for this episode. Family, I'm your host, Goodwille Pierre, attorney Goodwille Pierre. Please make sure you like, subscribe, and share, especially with those with like minds and want to just share. Please, if you have any questions or anything that you think should be a topic on Success in Business, the podcast, email us at info@successinbusiness.org, info@successinbusiness.org. Definitely go to our Instagram at Success in Business, Facebook at True Success in Business, TikTok at Success in Business 4. And always, 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 please come back, share, and I wish you success in business. God bless.